Welcome to the Legal Influence Podcast, a show for influencers and content creators looking to grow thriving and influential businesses legally. I'm your host, Kate Cooper. I'm a Colorado attorney, an outdoor content creator, and blogger, and I started the Legal Influence to provide accessible legal education to creators. In today's episode, I'm going to talk about everyone's favorite topic, FTC disclosure obligations, and I'm going to bust some common myths and misconceptions regarding when and how disclosures need to be made in the US. But before I dive in, I do have to provide some quick disclaimers. Nothing I share today should be considered legal advice. Everything I'm sharing is coming straight from the FTC and is for informational and educational purposes only. While I am an attorney, I am not your attorney, and listening to this episode does not create an attorney-client relationship between you and I. So the first thing that I want to discuss is why creators have disclosure obligations in the first place. And it really comes down to transparency and truth in advertising. It's important for consumers to know when they're being advertised to and when somebody might have an interest in making the statements that they're making. For influencers specifically, beyond the legal obligation, it's really important to be honest and transparent with your audience. Trust is the most valuable thing that you have as an influencer. If you lose your trust with your audience, you're going to have a hard time getting people to buy from you. You're going to have a hard time landing future brand deals. You're going to have a hard time finding success long term. And so being super upfront and transparent about the brands that you're working with is so important. Ultimately, not providing disclosures is deceptive and misleading to your audience, and they're the people who are ultimately supporting you as a creator. I also want to note that in today's episode, I'm specifically talking about FTC disclosure obligations. That's the Federal Trade Commission in the United States, and these regulations apply to anyone advertising to U.S. consumers. Keep in mind that other countries also have their own disclosure obligations, and there's typically a lot of overlap, but some countries do have more specific guidance around language that they require than the United States has. So, what are the potential risks of not making a proper disclosure? In the US, the potential fines for not providing a proper disclosure are pretty steep, up to about $50,000 per violation. So, you really don't want to get on the FTC's radar at all, even if the odds of them coming after you are low. At least for me personally, it's just not a risk that's worth taking. Now, the most likely scenario that might trigger the FTC to look into you and your disclosures is working with a brand or on a campaign where there are sweeping concerns around disclosures. It's not one influencer who's not disclosing properly. Like there's something kind of prolific about the number of improper disclosures happening here. And this actually happened last year. There was a campaign where 12 registered dietitians who were also creators worked with the American Beverage Association and the Canadian Sugar Institute on some sponsored content. And all of the dietitians made disclosures in their posts, specifically in the captions, but the FTC thought that the disclosures were potentially misleading and sent warning letters to the influencers and the trade groups. In other words, they made disclosures, but they just weren't good enough in the eyes of the FTC. And a big part of that was because in this case, these were experts making health claims. You know, the statements made by a registered dietitian are going to hold more weight than statements made by somebody like me who doesn't have health credentials. But it was this campaign overall that led the FTC to start looking into each of these creators specifically. And in the grand scheme of commerce, influencer marketing is still fairly new, so we really don't know what enforcement might start looking like in the future. Influencers not making disclosures at all is a really big issue in the industry, so that could be something that the FTC decides to start really cracking down on in the future. And just as a quick side note, if you are ever contacted by the FTC or get a warning letter, you definitely want to get an attorney involved to help you navigate the situation. So I also want to talk about another situation kind of along the same lines that is very concerning. So apparently there are brands out there that are asking creators outright not to disclose their sponsored content or their relationship with the brand. And I'm just floored that well-established companies in some cases would do something like this. This is a huge red flag. Brands also have an obligation to ensure that the creators and the influencers that they work with provide proper disclosure. So they should be providing you with their guidance, which typically comes straight from the FTC. And I've noticed that really big consumer brands who likely have their own in-house counsel preparing influencer agreements tend to have the most robust disclosure policies. And this is a good thing. It shows that the brand is conscientious of their legal obligations and they're providing important information to you to help you protect yourself as well. But if a brand is asking you not to provide a disclosure, they're not looking out for you. And that is precisely the type of situation that is going to catch the FTC's attention. And you don't want to potentially get caught up in a brand's bad behavior. So let's dive into when you need to provide a disclosure. Basically, you are required to provide some sort of disclosure anytime that you make an endorsement about a brand that you have a material connection to. So this includes not only financial relationships where a brand pays you directly to promote a product, but it also includes employment, personal, or family relationships. And a financial relationship exists anytime that you receive something of value from a brand. So this obviously includes cash where the brand is actually paying you, but it also includes things like gifted products, comped hotel rooms, or plane tickets, and free services. Keep in mind that you are required to make this disclosure anytime that you endorse the brand. An endorsement can include statements made about a brand or a product. The FTC also considers things like tags, pins, and similar ways of showing you like a brand as an endorsement. So let me give you an example. Let's say you're going to work with a clothing brand on an upcoming campaign and you get the clothes in the mail, try them on, and you're immediately obsessed. So you want to share the outfit with your audience. You want to share it on stories, tag the brand. And so even though this story that you're sharing is not technically sponsored in the sense that you're not contractually obligated to share it, it's still an endorsement of the brand. So you have to provide some sort of disclosure. And this doesn't have to be something like hashtag sponsored or ad. As I'll talk more about in a minute, we have a lot of flexibility in the US when it comes to actually making a disclosure in terms of the language that we can use. It just needs to be obvious to whoever is seeing it. So in this example, you can say something like, I'm so excited to work with this brand on some upcoming content. And that simple statement makes it clear that you're going to be working with this brand. And so your connection to them is obvious. So let's talk more about how to make a proper disclosure. And I'm going to share some examples from the FTC as well. So as I just mentioned, you don't have to use specific language, but the language does need to be clear and simple. So this includes terms like ad, sponsored, or brand partner. It's also not necessary to use a hashtag with your disclosure, but you can. The FTC says that you should avoid using shorthand terms like spawn instead of sponsored or collab instead of collaboration because they may be confusing to consumers. The FTC also says that the words hosted or gifted are not sufficiently clear. Hosted is a term that is often used in the travel space when someone gets like a free hotel or Airbnb, but you really need to be providing more context than just the word hosted. Something like, thank you, hotel name for the free stay. You can also use those more general terms like brand partner. In this case, it would be hotel partner. That's my personal favorite to use, but something like hosted or gifted on its own is something other creators might understand, but it's not something that the average consumer necessarily understands. With regards to using gifted, the FTC says that you can say gifted by and then insert brand. Again, you just need to be providing some more context. You also need to provide the disclosure in the same language as the endorsement. So now let's talk about where to make this disclosure. This is something that the FTC has updated their guidance around over the past year, and this was the big issue in the sugar industry situation. So it's really important to know what the best practices are around where you're making your disclosures. So the disclosure should be placed with the endorsement. So if the endorsement is in a video, the disclosure should also be in the video, on the screen, and potentially in the audio if you're doing a voiceover, not just in the caption. Basically, the disclosure needs to be clear and conspicuous. And there are a few factors the FTC considers when making that determination. Number one is placement. The FTC says the disclosure should catch the user's attention where they aren't likely to miss it. So if you're putting the disclosure in a caption, it should be at the beginning of the caption before someone has to click read more. It shouldn't be at the bottom of the caption, and it shouldn't be buried with a bunch of other hashtags. Next is readability. It should be simple with a contrasting background. Something that influencers commonly do, especially in stories, is use that script font that's super hard to read, and then they make it white and put it against a white background so you can't see it at all. It's really going out of the way to hide the disclosure. And if you're doing that, it's probably not a sufficient disclosure. To be honest, when I see creators doing that, my first thought is, what else are you hiding? You know? My skeptical New Yorker comes out. Anyway, the last factor is clarity. It should be clear, unambiguous, and understandable to the ordinary reader. And that really goes back to the language that you use. So I want to highlight a couple of specific questions that the FTC has answered on their People Are Asking page, which will be linked in the show notes. But these are unique hypothetical situations that you might find yourself in. And I think it's interesting how the FTC recommends you navigate them. So the first question, I'm a skincare influencer and I have an endorsement deal with a brand. If I post negative comments about a competing brand, do I have to disclose my endorsement deal? The FTC's answer, yes. If you criticize a competitor of a brand that you are paid to endorse, you should disclose your paid relationship. It would likely affect the weight and credibility that your audience gives to your negative comments. Next question. An influencer creates their own brand and sells their product through their social media accounts and website. Do they need to disclose anything? The FTC's answer. If it's obvious from an influencer's endorsement that the brand is the influencer's own, no disclosure is necessary. If it's not clear or sometimes not clear that it's the influencer's brand, that fact should be disclosed. Next question. 2 months ago, I signed a 1-year contract with a company to promote its brand. Every time I've posted about the brand, I've disclosed my relationship. By now, my followers might have seen 8 disclosures that I'm working with the brand. Do I still have to disclose the relationship in every post going forward? The FTC's answer, each new endorsement made without a disclosure could be deceptive because viewers might not have seen the prior posts. In other words, yes, you still need to make the disclosure in every single post moving forward. And the last question I'm going to cover, I have a YouTube channel that focuses on hunting and camping. Sometimes I'll do a product review. Knife manufacturers know how much I love knives, so they send me knives as free gifts, hoping that I'll review them. I'm under no obligation to talk about any knife, and getting the knives as gifts really doesn't affect my judgment. Do I need to disclose when I'm talking about a knife I got for free? The FTC's answer, even if you don't think it affects your evaluation, what matters is whether the fact that you got the knife for free might affect how your audience views what you say about it. It doesn't matter that you aren't required to review every knife you receive. Your viewers may assess your review differently if they knew you got the knife for free, so we advise disclosing that fact. As I said in the beginning, the real purpose of providing these disclosures is for transparency. Your audience deserves to know this information. So I hope today's episode helped clear up any misconceptions you may have about FTC disclosures. Again, there are going to be resources from the FTC linked in the show notes if you want more information. Thanks so much for listening to the Legal Influence podcast. If you enjoyed today's episode, I would love for you to do me a favor. Screenshot the episode and share it in your Instagram story, tagging at the Legal Influence. Also, be sure to leave a rating and review. And if you know any influencers or content creators who would benefit from this episode, please send it on to them. Talk to you soon.